Yes.
Judge, just before we bring in the jury to call the next witness, I did just want to bring a legal issue to the court's attention. Attorney Schoenhorn indicated to me yesterday that he would be objecting to the AT&T records coming in without an authenticating witness. I don't know if that's still his position, but it was my intention to use those records at this time.
I will just note, Your Honor, that the state provided me with an affidavit which I believe does not comport with new Code of Evidence 9-3A, although there are two affidavits. One is dated yesterday, or maybe, what's the date? Not yesterday, a couple of days ago. The other is dated a couple of months ago. In any event, I submit that, well, there are two issues. One is it states that the specific records and the certification have to be provided in sufficiently in advance of the offer to provide an adverse party with a fair opportunity to challenge them. So this was provided within the last couple of days, this affidavit. But in any event, I don't believe the affidavit complies with subsection A3 of new 9-3A. It appears to, on its face, the business record affidavit comply with a federal rule. It specifically recites the federal rule, but Connecticut's Code of Evidence is different in that respect. And specifically, it requires that the affidavit state either that it is based on the entrant's own observations or on information of others whose business duty it was to transmit it to the entrant. And I submit that neither of those are in the affidavit. Therefore, I've indicated to Mr. McGinnis, actually at least 2 weeks ago, that I was going to request that an AT&T representative appear. And I had indicated even to Your Honor that part of the issue was to explore whether or not these records were obtained or were subject to erasure that were therefore obtained in violation of the Fourth Amendment. But I'm just sticking right now, we're not making a constitutional argument to my claim that under new Rule of Evidence 9-3A, which was approved in 2022, that the affidavits do not comport with the requirements of that section under the business record authentication requirement, and therefore a business custodian of records would be required to testify.
Judge, obviously I disagree. I think that the affidavit itself fully complies with 9-3A. Just with respect to notice the opposing party, my recollection is we've been going back and forth as to whether or not someone was going to be required. And it wasn't really until last week that Mr. Schoenhorn indicated yes, for sure, that he was going to demand that someone from AT&T be present. But I'll just note the following for the record. With respect to Mr. Doulos' records, I would imagine he's had those for several years, although I guess he could represent the specific date. I wasn't involved with the case at that point. And with respect to Mr. Konis's records, he's had those since at least November 16th, and that affidavit is, that was a more recent search warrant, as the court will recall. And I could pass forward a copy of one of the affidavits. They look the same if the court wants to, check it against the subsection. But I can tell you, Judge, that this affidavit fully complies with 9-3A. It indicates that the person making the affidavit is qualified to authenticate the records because they're familiar with how the records were created, managed, stored, and retrieved, that they are
makes an outgoing call to Mr. McElhinney, is my understanding. At 8:15 and at 8:26, Mr. Konis's device received incoming calls through the home cell site, putting, again, her device home at that moment. And then at 8:27, Mr. Dulos's device placed an outgoing call through the home cell site. That tells us at some point between 7:47 and 8:27, Mr. Dulos's device traveled from the Hartford area back to the residence.
Next slide. All right, and now we're jumping ahead to May 29, 2019, 8:39 a.m. to 9:13 a.m., and then 2:20 p.m. is the slide. Could you just indicate for the jury what we're looking at here?
Happy to. So on this morning at 8:39, Mr. Konis's device received again an incoming call through the home cell site. Roughly 18 minutes later, her device utilized this tower and sector here for an incoming call, before then utilizing this cell site up here adjacent to the Russell Speeder car wash. That was for an outgoing call at 9:12, and then followed by an incoming call at 9:13. Both of those numbers were with, both of those calls were with a number 203-918-4877, which was provided to me as another phone number for Mr. Dulos. Now, jumping forward in the day, we pick back up at 2:20. Ms. Traconis's device utilizes that same tower and different sector at 2:20 for an incoming text message, consistent with her device being back up in the area of the Russell Speeder car wash.
And I want to direct your attention to between 9:13 and 2:20, specifically approximately 1:40 in the afternoon. Did Ms. Traconis's device receive a phone call that's not reflected on this slide?
That's correct. So Ms. Traconis's device had received a phone call from a number associated with the Russell Speeder car wash. The cell site and location of that was not relevant to my analysis at the time and was not included on here, but the call itself did in fact take place.
Next slide. Okay. Thank you, Agent Horn. You can have a seat. Thank you. If I could just have a moment, Judge. Nothing further, Judge.
Thank you.
May I just return the exhibits?
Yes.
I'm just going to conclude. This isn't the only report you prepared with regard to this case, isn't that correct?
That's correct.
You prepared a separate report a month ago that included a third person, correct?
That is correct.
And that was the following, tracking the travels or the travels of the phone belonging to a Kent Mawhinney, correct?
That is correct.
And I would just mark this for identification. I'm just going to ask you if you recognize this, and then I'll show it to counsel.
Yes,
This is a report that you prepared,
that's correct.
and you prepared it in December,
Correct.
this past December.
Correct, yes.
I have no objection if counsel wants to introduce it.
What is the exhibit letter?
Double H, H.
Double H admitted as full.
I have no further questions.
The redirect.
I have nothing further, Judge.
Thank you. Mr. Hoyland, you may step down.
Thank you, Your Honor. Thank you.
Ladies and gentlemen, that concludes the state's witnesses for this afternoon. The court has been informed that there will be testimony tomorrow, and it'll be a lot of video testimony. In other words, video of interviews. And we'll adjust the break schedule accordingly as those interviews take hours. So have a good evening, and please do not discuss the case. Please